If a loved one has died in Texas and you need to probate their estate, whether or not they have a will, you will have to hire a lawyer to file an application for probate. You have to establish that the person has died, so you'll need a copy of their death certificate. And you'll also need some information about where they lived and where their assets are if you have that information. If a loved one has died and a will has been presented for probate that you don't believe is the right will or was a valid will, you can contest it. You would have to find a different will, something that you believe is more recent and is the valid will that should be probated to present to the court to prove that the one that is being offered for probate is not the correct will. Or if you think that that will was not executed with the correct formalities, or perhaps that your loved one didn't have capacity to sign the will at the time it was signed, you can bring forth witnesses and evidence to show that your loved one either was pressured or didn't know what they were signing when they signed it. In Texas, if you have a will in most counties, the probate process is about 6 months. If there is no will, it can be up to a year. If you have a trust, there's no need to go through probate. The trust owns all of the assets, and the trust will state who is the next beneficiary, whether the assets will be distributed directly to them or whether those assets will be held in trust. But it's a seamless transition because the assets are owned by the trust and don't have to be transferred from one person to another. We like to look and examine our clients' assets in the estate planning process to see if there are ways that we can avoid probate or limit probate, even if we are not creating a trust. Luckily, there's some good options for bypassing probate, even without a trust. One of those is something called a transfer on death deed. If you own property in the state of Texas, you and any other owner, such as your spouse, can execute something called this transfer on death deed, or a TOD. And that is an automatic transfer of the property once you have passed. All your loved one has to do is file an affidavit with the property records indicating that you have passed, and the date of death and a copy of your death certificate is filed with the property records, and then that property passes automatically. Other things that can be done to avoid probate is to transfer as many of your accounts into accounts that have beneficiary designations. Sometimes these types of accounts are called payable on death or transfer on death accounts, such as bank accounts. Or again, if they have a beneficiary designation where you can name the person that you want that asset to go to, that will avoid probate in that situation. If you have a will and there's an executor named and appointed to probate your estate, that executor can sell your house during the probate without any need to ask for any permission. If you don't have a will and your property has to go through an intestate administration, if the court is monitoring that estate, then you have to ask for permission from the court to sell the house, and that can create a long delay in getting that done and can be a lot more costly. A probate executor is responsible for finding all of the assets that were owned by the deceased person, making sure that if there are any debts, that those debts get paid. And then they are responsible for taking the remaining assets and distributing them in the way that the deceased person wanted. A lot of times that means they may be selling real estate, they may be consolidating financial accounts so that in the end they're just handing over a check to the beneficiary. If there's a mortgage on the house that is part of a probate, the mortgage has to be paid while the probate is pending. Otherwise, the mortgage company can come in and foreclose on the house at any time. If you have any questions about probate or the probate process, please give us a call at DeFord Law Firm.